The last will and testament really kind of shook his family up when his father passed on and he's trying to help his mother do the estate. And it's like, oh my gosh, all this stuff was so complicated, convoluted. How can you avoid probate? This can't have to happen. And that's when he started looking into a revocable living trust. Hi, Jeff Mersacci, the Plain English Attorney, and welcome to the video today. It's going to be a little bit more of a fun one with a little bit of history, and we're calling it legal hangovers. Well, what do I mean by that? It's things that just kind of hang over from previous times. There might have been some reason to do things a certain way, or people were talked into doing something a certain way, and we're just kind of on autopilot, and it just keeps going, kind of like if you've got a hangover, you're just kind of going through the motions and you're almost on autopilot. And look, the legal industry is no different. So let me give you just an off legal topic that we're going to talk about just to give you a sense of what I'm talking about with legal hangovers here. I always get looked at really weird. I'm not generally a breakfast food kind of person. I'm just not, or certainly not a breakfast food person at breakfast time. All right, so I'll have something like a grilled chicken sandwich, or I'll want a hamburger or a Whopper in the morning, something like that. And it's everyone's looking at me like, oh my gosh, how can you eat that in the morning? While they're shoving down a bacon, ham, and cheese biscuit on a buttered roll with a side of fried potatoes. It's like, how can your stomach deal with that? Well, really, all right, why do we eat what we eat in the morning? Why is there so much pork in the form of ham, bacon, and other things that people are eating in the morning? And it's like, that's it's too much cholesterol and all this other stuff. Well, why are we eating all of that stuff? And why are you looking at me weird if I want a hamburger in the morning? Well, the reason we do this is actually going back to a marketing scheme from the 1920s. And I'm getting this from an article on mental floss. I'll try to link that below. In the 1920s, the Beech Nut Packing Company found themselves with a surplus of bacon. To sell it, they created a need within the public to buy bacon. First step was to hire shrewd public relations guru Edward Bernays. Cereal had become a commercial success after whole wheat had been introduced as a healthy alternative to heavy meats, so Bernays just flipped the script. He convinced the company doctor to agree that our farming forefathers had it right all along. Meat was the right way to start your day. And from there, he found 5,000 other doctors to also sign off on the totally untested claim. He published their endorsements as if it was a medical study, and just like that, the public started buying bacon. So yeah, we're having bacon and ham and sausage and all this other stuff in the morning with a lot of grease, and everybody's just accepts it because of this advertising campaign back in the 1920s, and it just sort of coasted along. Okay, so this is how we eat breakfast in the morning in the US because, well, we were talked into it by a, quote, medical study that wasn't actually a medical study. So what legal hangovers do we have? If you think it's important for educational videos like this to get out there, then please help us out by subscribing to the channel. Well, okay, we're going to go with a top one that's still out there. 8.5 by 11 paper. Legal sized paper. Why is the rest of the country and a lot of the world using 8.5 by 11, but we still use 8.5 by 14 paper in the legal industry? Why do we have legal sized paper? Now, to be fair, it's not like attorneys do everything on legal paper, but hey, on official documents, deeds, wills, in some cases, filings with the court and motions, sometimes they're using legal size paper for all of that stuff. But why? This is actually going all the way back to the Stamp Act, prior to the United States being the United States and just being a colony. This is the Stamp Act was a way for the British government to raise revenue, and they were taxing legal documents, and every page had to have a stamp and pay a tax on it. And the maximum size paper you could use was 8.5 by 14. Okay, so legal sized paper is around because prior to us actually being a official independent country, we were trying to save a little bit on taxes, and so we'd use that maximum size paper. And it's still around. And now there are entire industries around legal sized paper. Go ahead and look online for filing cabinets that are 8.5 by 11 and look at those prices. And then check out filing cabinets that hold files that are 8.5 by 14, and there's a huge jump in price. And well, look, if you're a law office and you've got legal sized document paper, you got to have the filing cabinets to hold it. So here it is. It's all from the Stamp Act. Okay, now, as ridiculous as that sounds, and it is pretty ridiculous, there is again, a slight reason why some attorneys may still be doing this. And I actually encountered this for quite some time. In North Carolina, you used to pay, I think it was like $14 a page, and then like $2 or $3 additional for each additional page when you're filing something with the Register of Deeds office. So part of our common practice with estate planning, we'd do the deeds putting property into a revocable living trust. And so we had to file that deed. Okay, we'd get the text as small as it can legally be and yet still meet the requirements for the Register of Deeds office. And even then, it used to be where, okay, it's not going to fit. And we used legal size paper to save on that $3 on the back end. Well, North Carolina changed their filing fees, and it's now like $26, and it covers, I don't know, it's like 10 to 20 pages, something like that. When we're filing deeds for our clients with revocable living trusts, it's never getting over that amount when we have to pay additional, but it's still around. So if it's not just North Carolina, it might be other states. When you're filing something with the Register of Deeds office and you have to pay a fee per page, here's this 8.5 by 14 requirement. It's like, well, okay, we can save a couple of bucks here and there. And depending on volume, it may really add up. So this is where that comes from, but it's still around. All right, what else do we have? Now, this is when you're doing revocable living trusts, most of the time when we're working with a couple, we're doing a joint revocable living trust. But depending on what part of the country you're in, that may be, oh, no, you don't do it that way. You always use two trusts for a couple. And you go to other parts of the country, it's like, oh, no. Look, you can do this as a single joint revocable trust. That's not a problem. It's, well, wait a minute. Where did all this come from? And this is a story coming from the late, great Henry W. Epps III. He actually wrote the book, The Living Trust. It's still kind of a authoritative text for the public that really goes deep into, here's the difference between a will and a trust. Why does the revocable living trust work? Why is it considered a better way to do things? And even though its latest publishing is decades old and Henry's now passed on, the numbers for taxes are way, way off inside. But it still gives you that background in the reasoning behind revocable living trusts and a little bit of the history of it. So it's still a good book, but it's really thick. Most of my clients, going way back, I said, well, look, this is a good book. You want to read this. A couple hundred pages. You know, you're a law student, that's light reading, but no. This is why I have my book, Estate Planning Basics, and it's inside a free course that we put online. It's kind of mandatory reading for my clients before we sit down and start talking about estate planning. And it's at freetrustcourse.com. So go ahead at freetrustcourse.com. You can sign up for that, get that information. And we do put some entertaining stories and examples that are in there too. But now when Henry Apps is talking about revocable living trust, he was really at the forefront of publicizing and pushing this as an alternative to a last will and testament. The last will and testament really kind of shook his family up when his father passed on and he's trying to help his mother do the estate. And it's like, oh my gosh, all this stuff was so complicated, convoluted. How can you avoid probate if, this can't have to happen? And that's when he started looking into a revocable living trust. Well, at that point, he was in California and he started doing seminars and talking with the public and getting groups of people and suddenly large groups of people. And he started doing it locally in California and then started moving east. So he was giving all these seminars and connecting with attorneys and financial advisors across the country and going all the way out. And it's kind of like out to the Mississippi and then kind of up through into the Northeast. At the same time, there were these two attorneys in Florida who were doing the same thing, talking about revocable living trusts. And this is the way to avoid probate. And this is a better way to do your estate plan. And they're coming up through Florida and the Southeast and getting up towards the North. Henry was saying, well, wait a minute, we can do a joint revocable living trust for a couple if they were trying to preserve estate tax credits. And this is back when it was about $600,000 was exempt from estate taxes. There were a lot more estates that would be subject to estate taxes. We can preserve both of a couple's credits and do all the math within the trust. These two attorneys down in Florida are like, oh, no, you need to preserve both tax credits, so you have to do two separate trusts. Now, the issue with that is you've got these two separate trusts. If you've got a husband and wife, you're now every year or more often having to balance the assets between the two so that neither one really gets too high over the other. And it's just this perpetual back and forth. Well, okay, Henry's stuff, the math can be done within the trust. Well, now we're at these exemptions where currently 2025, it's 13.99 million per person. And we can do the math inside that basically doubles it up to 28 million for a married couple. You can do all of this math inside the trust. We still see in our area and still going all the way up into the almost getting to the Northeast, the Mid-Atlantic. The whole legal theory is no, you use two separate trusts for a couple because that's the way we've done it. Well, wait. Most of my clients are going to use, if it's a couple, they're going to use a joint revocable living trust. There are cases where individually it makes sense, but you're being a little bit lazy by just jumping to you always do this or you always do that. When do separate trusts work for a couple? All right. If you have different people that you want to be trustees, you have different distributions than the other, and you just have a different kind of overall plan, which we see a lot when there are second marriages later in life. They've got their own kids, they've got their own assets. Well, then separate revocable living trusts make sense in that particular case. With the Estate Patch system, you can pick your own plan. This service of the Care Assistance Center, LLC, can provide U.S. adults with the estate documents they need without having to hire an attorney. If you want to handle these documents yourself, then our licensed document creation system can help you create your own documents, while our original courses and materials can help you maximize your plan and help maintain it. You can pick your own plan. When we have couples, they have just joint children, or even if it's a second relationship, but it was early on, all right, we can do a little bit with the beneficiaries. but they want to combine everything. They want one overall plan. They agree on who the successor trustees are. Well, look, there's no reason not to do a joint revocable living trust in those circumstances. The point is, you just don't go on autopilot and say, well, this is the way we've always done it. There's so much stuff in the legal industry where it's, well, this is how we've always done it, so this is just what we're going to do. And it just completely stunts creativity. This is probably getting a little bit more into, me personally and how I looked at things. I never got, quote, brainwashed by working in a law firm and this is how we've always done it. I kind of went right into doing my own thing out of law school, passing the bar, opened my own firm, and just went on that premise. And so a lot of the legal research I did in the areas of law I was practicing in, which primarily ended up being estate planning, I started looking at, all right, what's the goal? What's the objective? How's the best way to get there? And I didn't get all of this. Well, no, you don't do it that way. We do it this way. Well, why? Well, because that's how we've always done it. I've always tried to look creatively and find a way to solve a problem rather than just follow what had been done before without thinking about it. In other words, look, if there's a lot of cholesterol that's in bacon, egg, and buttered buns and biscuits and gravy and all this other crap, if everybody's going to be okay having that for breakfast, well, then why can't I have a Whopper? All right. So what are some other areas? Well, we've got another one. And I hear this all the time. Oh, you need tenancy by the entirety on deeds rather than having your real estate go into your revocable living trust. And I remember having this discussion with another attorney, a very good one. But she was getting berated by a colleague. Why would you ever put the house into the trust? I don't see any reason to do that with the primary residence, because with tenancy by the entirety, the couple has some lawsuit and bankruptcy protection. Well, yeah, they do. All right, but it's only if it's against one spouse. So if one spouse gets into a car accident in their separate vehicle and they're being sued, they can't get to the house as tenancy by the entirety because it takes the house away from the other spouse. Well, most of the time when you're talking about creditors trying to get at a house, it's for a married couple, it's joint debts. So that doesn't really do anything. It goes into the trust. It avoids probate. It has trustee control. It's much easier to buy and sell things after death if it's just one trustee instead of like 4 beneficiaries who end up getting it. It's just, in my experience, there's an awful lot more that has to go into it, a lot more paperwork and getting the beneficiaries to sign off if it's left outside the trust. But wait a minute, we've got this bankruptcy and lawsuit protection. If you think it's important for educational videos like this to get out there, then please help us out by subscribing to the channel. All right, here's the best way to look at it. What are the chances you're going to be sued to the point where you're actually not covered by insurance? It's just, it's exceeding your insurance limits. What are the odds of that happening versus the odds you're going to die one day? Well, that's 100%. We do not have anybody on this planet who has lived forever. At some point, you're going to die. Well, what about that bankruptcy and lawsuit protection? Well, look, if you're really that concerned about it, then you need to think about it. Now we're talking about things like irrevocable trust, domestic asset protection trusts, not this kind of duct tape solution of just keep it as tenancy by the entirety. I also see the same attitude occasionally, not nearly as much, and it's not with the legal industry, it's with life insurance. What we talk about with a couple is you're going to make your life insurance payable upon death to the trust, because now it avoids probate and it avoids, well, what if this person dies and then the other person dies before the money's collected and then it ends up in their probate? No, just send it to the trust. But I still occasionally, for the same reason, hear, oh, you want the spouse to be the beneficiary for life insurance, or oh, you want the kids to be the beneficiaries or the contingent beneficiaries because there's creditor protection for that life insurance. So even if you got huge amounts of debt, this life insurance going to these beneficiaries is going to be exempt from creditors. Well, if you're going to get organized and you're going to do a revocable living trust, let's talk about these other legal issues as part of it. Let's not just throw it to, well, this is the way we've always done it. Just as a little bit of a side, yeah, North Carolina does have life insurance being exempt from creditors of an estate if it's going to certain family members, and that's in our state constitution. Yeah, but let's look at the overall thing and actually think about it instead of being in a legal hangover and just going on autopilot. Another one, being complete with the trust. I see this all the time. It's just, it's lazy. That's what it is. It's actually lazy. If you have a revocable living trust and you just state, well, we're incorporating all of the powers of this state law section that goes into trust. We're basically adopting what the state says. This is coming into our trust. Well, you're kind of then letting state law not just fill in the blanks, but fill in almost all the blanks. There's a reason why I don't like taking continuing legal education courses to fulfill my requirements. North Carolina actually allows, and most states allow, that you get credits for teaching about subjects to attorneys. And every year there's the Advanced Institute with the estate planning source where I go ahead and I take at least a couple of classes and teach. And the good thing with North Carolina, I actually get 6 credit hours for every hour that I teach. And the reason they give you extra credit is because you end up doing an awful lot of research and trying to get all the materials together. You're putting in 6 hours of work per hour, if not more. But many years ago, I attended this day-long estate planning CLE, and it was like 2.5 hours on the, I might be messing up the numbers, 186 changes to trust law this past year. And it really was a rundown of it. Well, let me tell you something. 184 out of the 186 were, well, if the trust doesn't say, then here's what the law says it means. Well, then why don't you just put it into the trust? And then I went through and looked through the documents 184 times. All of it was already covered in the trust. I didn't have to reference state law, which, by the way, can be changed, can be subject to interpretation by courts. And if you're just relying on it and there's a question, it's like, well, this is a legal court question. We need to go into court because we didn't spell it out in the trust document. Again, lazy. Well, why would you do that? Again, 184 out of 186 were, if the law doesn't say, then this is what goes in. The other 2, I think they were like temporary tax references that had to be in the trust. And I remember one of them was like a tax deduction for fish hatcheries. And there's something in the law said if you're going to put your fish hatchery business in your trust, then the trust has to say this if you want this specific tax credit, and it's only for a couple of years. Just put it in the trust. But I see it all the time with what Henry Apps used to call thin trusts. It would just lay out, okay, here are some of the specifics that the client wanted, and everything else is just reliance on state statutes and interpretations. No, spell it out. So that's one of the reasons why our trusts are really thick. It's like all of these different things have been thought about. Look, 75% of it may not apply to your particular situation, at least when you're doing the planning in the front end, but down the road it may be. The biggest example of that is, what if you end up with a beneficiary who's disabled or they're on Medicaid as their health insurance, and getting an inheritance might mess up those benefits. Why would you want to put that in jeopardy by having inferior language? So there's some real thick language that's in there that covers all these situations to make absolutely sure they're not going to lose their benefits. Oh, but none of my beneficiaries are disabled. Yeah, now, if something happens and you pass on before you have a chance to come back and add that particular language because the situation has changed, well, then your beneficiary may end up losing their benefits. We already put it in. And now here's the big one, the granddaddy of all of it. Oh, well, just use a last will and testament. You have less than the taxable limit. You have less than 14 million, so you don't need a trust. This is like saying, oh, you don't need to change the oil in your car because your gas tank is full. One of them has absolutely nothing to do with the other. When you're talking about estate tax credits and limits and whatnot, all right, you're talking about that $14 million limit. But a revocable living trust at its core isn't about saving on estate taxes if you have more than 14 million. It's about avoiding probate court and making sure that your estate stays out of the government controlled process of court with all the bureaucracy and all the red tape and all the, well, we need to see a copy of the invoice and a copy of the canceled check. We need to line it up with the bank accounts and all this other stuff that has to happen that ends up making probate cost anywhere from 4 to 10%. Takes 6 months to a year and a half to settle this finally, and 2 years is really nothing. Everything that goes into probate is open to the public, and it's a lot easier to contest things. Those are the big 4 downsides of probate. We got other videos on that, and it is, again, mentioned in my book, Estate Planning Basics, which we have inside the course at freetrustcourse.com. Look, a revocable living trust isn't necessarily for everybody, but it's for a lot more people than the state, not the state bar, but the attorneys that are out there doing estate planning may let on, because they're the ones getting a lot of that 4 to 10% of the estate, or they just don't know better. They've always been told, oh, you use a last will and testament unless they're in an area where we have to worry about estate taxation. No. The smart attorneys will make an analysis and not just look at some arbitrary number that they were told by their firm and their predecessors. They'll actually think about it and do a weighing of goals. Is it worth the cost and expense to do a revocable living trust on the front end to avoid all of the issues on the back end for the family? You make that cost benefit analysis and you decide, are you going to use a trust and avoid probate, or is a will fitting with your goals? I go through that same analysis with my clients. And in fact, a lot of them kind of come into my office for that first meeting after having read Estate Planning Basics, and they know which direction they're going in, one way or the other. So this question of, do you do a will versus a trust, doesn't come down to, well, we've always been told if it's taxable, then a taxable estate, then you use a trust, but otherwise you don't. No, that just doesn't cut it. All right. So as I mentioned, we've got those free resources at freetrustcourse.com. It's got my book, Estate Planning Basics. It's also got some other stuff in there. It's got my the questionnaire that we use in my law office for clients to fill out before they have their meeting. So even if you're not going to become a legal client of ours, you're outside of North Carolina, it's still a good resource to take a look through, because 95% of it is probably what another attorney in your area would look at. So it'll help you get organized. And there's other stuff in there, like how do you really address the big 4 questions of who should be doing what, and just a little bit of advice there. But it's out there. It's free. Go ahead and take advantage of it at freetrustcourse.com. All right. So let's close out with that. And as I always tell my clients, please stay safe, plan ahead, and enjoy life. And whatever you do, make it a great day.